Hi friends, good morning. Welcome to Annamaya IAS Academy. This is Dr. Harinath Reddy, Director of the Institute. Today in this particular video, we will try to discuss the questions which have come on Indian polity in the UPSC Epfo paper of 2023. So in the year 2023, there was one exam conducted by UPSC related to Epfo, Employee Provident Fund Organization, for the post of Assistant Provident Fund Commissioner. So a total of 10 questions have come on Indian polity. Let us discuss every question which has come in 2023. How does this help you? So by going through the questions which have come in the past in the UPSC Epfo exam, you can make an analysis of how the questions are coming, what is the level of difficulty, where they are coming from, what are the areas where these questions are coming from. So if you go through all the questions on Indian polity in the last several papers of Epfo exam, you can make out a plan for dealing with polity, how polity has to be read, which areas are to be focused upon, and what is the level of difficulty. So once you get to know about these things, your preparation for polity becomes much more easy and much more focused and systematic. See the first question. The right of workers to resort to strike is, so the right to strike, is it a fundamental right? Is it a statutory right? Is it a common law right? Is it an equitable right? So for answering this question, you need to rely on the judgment of the Indian Supreme Court. So in the Constitution of India, it is not laid down that a right to strike, though it is part of freedom of speech and expression, the Supreme Court has categorically said it is not a fundamental right. Especially there was one case, Rangarajan versus State of Tamil Nadu, Government of Tamil Nadu, in 2003. In 2003, in Rangarajan versus Government of Tamil Nadu, the Supreme Court said right to strike is not only not a fundamental right, it is not even a statutory right, it is not even a moral right, especially for the government employees. So employees who are working for the government, either the state government or the central government, for them the right to strike is neither a fundamental right nor even a statutory or moral right. And as part of the judgment, the Supreme Court said it comes under common law right for those who are non-government employees. So employees not working for the government, they will have one form of some kind of right to strike, that too which is categorized as common law right. So students may have a tendency to put statutory right as the answer, but it is not the right answer. So the right of workers to resort to strike is neither a fundamental right nor a statutory right. It is a common law right. It may seem for you quite unusual because you might have never read about common law right anywhere in the Constitution of India. But the Supreme Court in its judgment has referred that a right to strike comes under common law right. So the answer is C. Then the next question, question number 2. Which of the following statements regarding the ordinance making power of the governor is or not correct? So the question is not correct. Take the first statement. It is a discretionary power and does not entail the advice of the ministers. It is a discretionary power. Is it a discretionary power? That is the question. The power of the governor to issue ordinance is not a discretionary power. This power is exercised on the advice of the State Council of Ministers headed by Chief Minister. Similarly, when the Parliament is not in session, when there is a purpose of immediate action, when there is emergency, when the Parliament is not in session, President can also issue ordinance. But remember, this is not a discretionary power. This is a power which can be exercised by both the President and the Governor only on the advice of the Council of Ministers headed by Prime Minister or Chief Minister. So statement 1 Not correct. Let's take the second statement. The ordinance making power of the governor is confined to subjects in all the three lists of the 7th schedule. This is not correct. Why? The president can issue ordinances with respect to subjects in the union list as well as the subjects in the concurrent list, because Parliament has the competence to make laws with respect to subjects in the union list and also with respect to subjects in the concurrent list. So the power to issue ordinance is a legislative power, not an executive power. So the power of the president to issue ordinance, it is a coterminous with the powers of the Parliament. In other words, the president can issue ordinances with respect to all the subjects where the Parliament has the power. Similarly, if you take governor, governor can issue ordinances with respect to the subjects in the state list and also with respect to subjects in the concurrent list. But the statement says in the 7th schedule there are three lists, list 1, list 2, list 3. With respect to all the three lists, the governor can issue ordinance, which is wrong statement. The governor cannot issue ordinance with respect to a subject in the union list. So first statement is incorrect, second statement is incorrect. Take the third statement. With regard to repugnancy, repugnancy means conflict. With regard to repugnancy with a union law relating to the concurrent subjects, the governor's ordinance will prevail notwithstanding repugnancy if the ordinance had been made in pursuance of instructions of the President of India. So you all know that with respect to a subject in the concurrent list, the President can issue ordinance, governor can issue ordinance. But if there is a conflict between the ordinance issued by the President and the governor, the ordinance issued by the President will have supremacy. But there is an exception. If there is an ordinance issued by the governor on a subject in the concurrent list with the prior recommendation of the President or with the consent of the President, then that ordinance will prevail over the ordinance issued by the President. So this is a right statement. Out of these three statements, incorrect statements are 1 and 2. Question number 3. Which of the following statements about a curative petition is or correct? Curative petition. Remember, review petition, it is mentioned in the Constitution of India, but a curative petition is not mentioned in the Constitution of India. So curative petition is the last means for knocking the doors of the Supreme Court to get justice when there is a miscarriage of justice or when there is abuse of court process. So this curative petition was evolved by the Supreme Court in a case called Rupa Ashok Hurra versus Ashok Hurra. This is the case in which the Supreme Court has come up with the concept of curative petition. And remember, you don't have curative petition at the level of the High Court. High Courts do not have the power to admit curative petitions. So if there is a judgment of the Supreme Court, if you are not happy with the Supreme Court, you can file review petition. And after the judgment is given by the Supreme Court on the review petition, still if you are not happy, the final remedy for you is curative petition. So curative petition does not find a mention in the Constitution of India. This is evaluated by the Supreme Court in one of the cases called Rupa Ashok Hurra versus Ashok Hurra. Let us see the statements now. It can be entertained by the Supreme Court of India only. This is a correct statement. So curative petition is the power of the Supreme Court. This power is not available to the High Courts. Correct statement. Then it can be entertained by the Supreme Court of India and the High Courts of India. This is an incorrect statement. Certification by a senior advocate is necessary to file a curative petition because the time of the court is very valuable. Many a times, if a frivolous curative petitions are filed before the Supreme Court, it will waste the time of the Supreme Court. That's why before a curative petition is filed before the Supreme Court, it is gone through by the senior advocate. If the senior advocate confirms that there is a merit in a curative petition, then it goes before the Supreme Court. So the third statement is correct. Second statement is incorrect. So he is asking, select the correct answer using the codes given below. So first statement is correct, third statement is correct. So the answer is D, 1 and 3. 1 and 3. Then question number 4. Consider the following statements. This is about Department of Economic Affairs, the functions of the Department of Economic Affairs. The Department of Economic Affairs is a nodal agency of the Government of India to formulate and monitor the country's economic policies and programs that have a bearing on the domestic and international aspects of economic management. So this is a correct statement. The principal responsibility of the Department of Economic Affairs is the preparation and presentation of the union budget, including the railway budget before the parliament, and the budgets for union territories and states under the president rule. This is also a correct statement. So earlier we have a separate railway budget, now railway budget is merged with the union budget. So when there was a separate railway budget, this was prepared by the Ministry of Railways, but now we don't have a separate railway budget, it is part and parcel of the union budget. So including the proposals, budget estimates for railways, it is prepared by the Department of Economic Affairs only. Union budget including the railway budget is now being prepared by Department of Economic Affairs in the Ministry of Finance. So both statements were correct, 1 and 2. Question number 5. Which of the following statements regarding District Planning Committee and the Metropolitan Planning Committee is or correct? You know that the 73rd Amendment to the Indian Constitution in 1992 and the 74th Amendment to the Indian Constitution in 1992, they provided for the establishment of two kinds of planning committees. District Planning Committee under Article 243 ZD